Hi, everyone. Welcome to Crime in Court. This is the Menendez brothers' Path to Freedom. I'm here with some breaking news. Today is the day of the Menendez brothers' resentencing hearing. It's a 2-day hearing and will last today, Thursday, April 17th, and Friday, April 18th, and potentially longer if need be. Last week, we had a hearing where Nathan Hochman and his team, the LA DA's office, decided that they were going to oppose the resentencing. And they argued for more than 2 hours about, all of the old 1990s facts, but nothing about rehabilitation or who the men are today. And basically, that was denied pretty he lost pretty bad, and the judge said, "We're gonna move forward with the resentencing next week." It is now next week. We're here, and on the very eve of the resentencing hearing, so late last night, Nathan Hochman's team filed a motion to continue the resentencing hearing, basically trying to delay this hearing yet again. It's already been delayed twice. So the first time, if you recall, I want to say that was in December, it was scheduled, and it was delayed because there was an election. A new DA was put into office, and they wanted to give the new administration time to catch up on the case so that it wasn't, right when he stepped into office and had to make this huge decision. So then it was rescheduled for January of this year, and the LA fires took place around that time, and they were rescheduled. And then right before they were rescheduled, though, then we learned that there was the risk assessment that was taking place, which comes into play in their motion. So we'll get into that in a little bit too. But so the risk assessment was, kind of in play, and they were waiting to find out when, how long that would take, but it didn't need to be, it's totally separate. So it doesn't have to take place after the risk assessment. This resentencing doesn't have to take place after the risk assessment. So it was scheduled, and it's on the calendar for today and tomorrow. But not if Nathan Hochman has anything to do with it. So actually, let's get started. So we're going to watch a press conference of today, right before they go in. So the court was like, okay, well, I'll hear your motion to continue the hearing, and then if he allowed it, then they would cancel the hearing. But if he denied it, then the hearings would go forward. So the hearings were still on the docket as of this morning, and so was this motion to continue. So this is outside the courthouse right before they argue the motion. Mark Garagos, understandably, a little upset about what's going on with Nathan Hochman, because this is kind of dirty and underhanded to do this like last minute, especially when you've already like stressed the family out enough and re-traumatized them. So let's watch this clip. This one's brief, and then we'll read the document that Nathan Hochman filed, or his team filed late last night, and then we will find out the conclusion. So let's get started here.
Okay, I have one request. I'll do something now, but then can I go stand unassaulted over there so I can prepare? That a deal?
It's kind of a strong word.
What? Yeah. Okay. So that you understand, the DA did file a motion to continue. I don't expect that His Honor is going to grant that motion to continue. I do, however, think that it's appalling, for lack of a better term, how the DA has treated this case. By the way, Marsy's Law, which is a constitutional law in the state of California, requires certain things of prosecutors and duties for victims. I don't know why, in this case, this this particular DA, because it certainly was not the last DA, but this particular DA has decided that he's got some other interest to vindicate that has nothing to do with the victims. There are people in this courtroom or will be in this courtroom that have been following these proceedings that have lived this case for 35 years. They're the victims. They have the unique situation of both being victims in this case and relatives of the defendants. Because of that unique nature, apparently the DA has said he gets a constitutional hall pass from doing anything regarding those victims, supporting those victims, notifying those victims, or anything else. He has abused the victims privately. He has abused them publicly. Just this last Friday, you were all here when they flashed grisly crime scene photos on the screen. I had to, in fact, it took me a second, because normally it would be the DA who would jump up and object to that. Instead, it fell upon the defense to jump up and object to that. The DA, to his credit, apologized. And then you know what he did? He went and he organized a protest against the resentencing on Sunday morning while Terry Beralt was lying in a hospital after being found unconscious that morning on Sunday. He organized a protest. He hired the then one lawyer in all of California that supposedly found Kathy Cady, or the Milton Anderson supposedly found the one lawyer, Kathy Cady, who happened to endorse his election. Kathy Cady was then hired as his head of victim services, and when the victims in this case complained, his suggestion was as he had walled her off. Guess who was part of and gave a interview on Sunday at the protest? A woman who claims to be Kathy Cady's best friend is now protesting against the resentencing. I would suggest that if anybody was an intrepid reporter, they might ask that woman, did you talk to Kathy Cady? Have you talked to Kathy Cady? Why is it that this DA is abusing the victims? Why is it that he thinks it's appropriate to go hold a press conference when one of his actions 30 hours later arguably put one of the matriarch of this family into the hospital after being found unresponsive, and when her daughter posted on Friday that her mother, when they went to dinner, was extremely upset because in 35 years she'd never seen the picture? I would ask you to ask the DA that. I would ask you to ask the DA why at the last minute he does a Hail Mary filing of a motion to continue and does not notify any of the victims or the victim's lawyer. Why? What is going on? Whose interest is he vindicating? Who has he been taken hostage? Ask him those questions. Ask him if he's vindicating victims' rights, the public's rights, or if he's just trying to placate some disgruntled DAs in his own office for political purposes. Thank you very much. No questions. I'll talk to you afterwards.
Hear from the brothers.
So he's not going to answer questions. He said it eloquently. I'm not even going to rehash because it's just, he's frustrated. I sense his frustration. I think Nathan Hochman should be recalled. In California, you can have a recall election and recall your district attorneys. So you're welcome, California. Go ahead and get that process started. I have no idea what it takes to do that. I just knew how to Google. Or actually, Grok. Grok told me I don't use Google anymore because Google is always wrong. All right, so let's move on. Let me switch my screen here. All right, so this is the actual document that Nathan Hochman and his team filed. So again, we've got Nathan Hochman, Habib Balian, Ethan Milius, and Seth Carmack. So those are the people with the DA's office that are pushing for this to the halt of their resentencing. Basically, they don't want them released. So this is the people's conditional motion to continue resentencing. Blah, blah, blah. Let me start over. I was trying to do two things at once, which is impossible for me. All right, so people's conditional motion to continue resentencing hearing if necessitated for the court to obtain additional information. It says time, 8:30 today. It was listened, they heard oral arguments. To the Honorable Michael V. Jessic, Judge presiding, defendants Erik Galen Menendez and Joseph Lyle Menendez and their attorneys of record. Please take note, pursuant to Penal Code Section 1050, that on April 17th, 2025 at 8:30 a.m. in Department S, or as soon thereafter as the matter may be heard, counsel for the people will move for a continuance of the resentencing hearing if necessary for the following reason or good cause. The people will request a continuance if necessary for the court to obtain the recently completed comprehensive risk assessments from the parole board. This motion will be based on this notice and motion, the pleadings in this case, the attached points and authorities in declaration, and such other and further evidence and argument as may be adduced at the hearing of this motion. So basically, as you can see, they want to continue the hearing because they want this comprehensive risk assessment that is going to be completed and given to the parole board, but it's not done. And as soon as the DA came out and made the announcement that he was, yeah, and after he filed this, basically this motion, Governor Newsom came out and said the risk assessment isn't done. Number one. Number two, the only portion that's done, it's only one portion that we've completed, and it's up to, it's to be determined. It might be changed. There may be things that need to be updated, or it's a draft. It's not the final. So you can't have it. It's not going to be completed until I want to say June, which is when they have their hearing with the parole board, I believe. I can't remember the date, but something along those lines. All right, so memorandum of points and authorities. Good cause exists to continue the resentencing hearing to provide the court time to obtain the comprehensive risk assessment that were completed by the parole board on April 15th, 2025. So they're saying the parole board completed the risk assessment on the 15th. Okay. But I know that Governor Newsom hasn't had a chance to review it or anything else. So I don't know. All right, so Penal Code 1050, a subdivision, subdivision B, allows any hearing in a criminal proceeding, including the trial, to be continued for good cause shown upon written notice served at least 2 court days in advance of the hearing. Well, first of all, you didn't serve it within 2 court days in advance of the hearing, so you failed on that. Notwithstanding subdivision B, subdivision C of section 1050 allows a party to move for a continuance without prior written notice upon a showing of good cause. In this case, good cause exists to excuse compliance with the requirement of written notice. So they're saying we didn't have to give you written notice for good reason. The declaration of Habib Balian. So we'll read that shortly. The people request that the court, at the conclusion of the hearing on the motion and based upon the declaration of counsel, make a finding of good cause for failure to comply with the notice requirement. It has long been established that continuances for good cause generally lie within the sound discretion of the presiding court. So they're saying, you have discretion to do this. So even though we didn't follow the rules and we didn't submit anything 2 days ahead of time, you have discretion to allow our motion, basically. You can just, circumvent the rules for us. Judges conference good cause to interpret preliminary hearing in the given circumstances. Continuance ruling reviewed for abuse of discretion. Accord Jensen versus Superior Court, People versus Johnson. Discussion of factors that did and did not constitute good cause to continue trial. As explained in the attached declaration, good cause may exist to continue the resentencing hearing in this matter. On April 15th, 2025, the people were made aware that the parole board has completed its comprehensive risk assessment reports for Eric and Lyle Menendez. Although the people were directed not to disclose these reports due to the governor's executive privilege for other reasons, the governor's office has invited the court to request these documents for use at the resentencing hearing. The court has already received prior risk assessment reports for both Eric and Lyle Menendez. Both parties have already cited and relied upon these reports extensively in these proceedings. There is no legitimate reason why the court should not now possess the most current and up-to-date risk assessments before making any resentencing decisions. Why can't you go forward in the resentencing hearing and then make your request for the documents from the governor and then delay a decision until you get those documents and review it? Like, you don't have to delay the whole hearing. This is ridiculous on its face. The people believe that the court should have all available information before making this important decision. To the extent the court needs additional time to obtain these documents from the governor's office, the people request a continuance as necessary. Conclusion: for the foregoing reasons, the people request the court make all reasonable efforts to obtain the recently completed comprehensive risk assessments from the governor's office. If additional time is required to obtain these documents, the people ask the court to continue the resentencing hearing. That's signed by them. And then here is the declaration of Habib A. Balian. And he was the one who did the arguments for the DA's office on Friday to basically rescind their resentencing request, which came from the prior administration. So he says, "My name is Habib A. Balian. I am attorney duly licensed to practice law in the state of California and am employed as a duty district attorney for the Los Angeles County District Attorney's Office. I am the assistant head deputy of the Major Crimes Division and one of the deputy district attorneys assigned to handle the resentencing matter in the above entitled case. I am informed and believe and declare as follows. On April 15th, 2025, I was notified by the parole board that documents were available for the people to download regarding the governor's clemency hearing process. Well, if you had them for download, can't you pass them along to the judge? Like, can't enter them into evidence so that the judge can see them? Like, why are you making us go through this whole thing? This is so ridiculous. He continues on saying, I accessed and downloaded these documents. Included within these documents were recently completed comprehensive risk assessments for both Eric and Lyle Menendez. Upon receiving these risk assessments, I inquired of both the parole board and the governor's office whether there was any statutory case law or other authority preventing me from using the documents or the information contained therein at the upcoming resentencing hearing before the court. I was informed that these documents were prepared at Governor Newsom's request to assist him with evaluating the clemency applications, and that the comprehensive risk assessments are just one part of the clemency investigation that the board is conducting, which will culminate with a hearing on June 13th. There you go. I knew it was June something. I was notified that the hearing officers who will conduct those hearings will consider the assessments as well as other documents and statements in making a recommendation to the governor, and that the purpose of the process is to gather information from the victims' family members, the prosecutor, Eric and Lyle, and their attorneys so that the governor can make a well-informed clemency decision. I was further informed that the complete risk assessments and clemency hearing are part of the governor's statutorily authorized clemency investigation process and are protected under the executive privilege as well as the deliberative process privilege. I was also informed that there are other reasons the people could not disclose the reports, including the fact that they may contain sensitive and protective information. So you can't just enter it into evidence, but can't you enter it and seal it? Like, can't you seal it so that the judge and all the attorneys have access to it and leave it at that? Like, why is this so difficult? Unless the executive privilege and the deliberative process privilege, whatever that is, doesn't allow them to do that. I don't know. All right, so in sum, the people were directed to maintain the confidentiality of the reports. On the same day, April 15th, 2025, I was also notified. Okay, I want to back up. It's one thing to saying maintaining the confidentiality of the reports. Can't you file it under seal and then it's confidential? Like you're maintaining that confidentiality by not making it public. So I don't know, unless, like I said, unless there were specific orders that they can't do that, but I have no idea. All right, so on the same day, April 15th, 2025, I was also notified by court personnel that the court was informed by the governor's office that the comprehensive risk assessments were completed and that the could request access to the documents so that the court could potentially have the risk assessments for its evaluation at the upcoming resentencing hearings. I subsequently informed the parole board that although they informed me that the people could not disclose the risk assessments at the resentencing hearing, I had received potentially conflicting information from the court because I was informed that the court was also given access to by the governor's office. The governor's office responded and informed me that, among other things, the court had been notified that 1. The parole board is conducting risk assessments of Erik and Lyle Menendez at the direction of the governor. 2. The board's process involves multiple components, including comprehensive risk assessments conducted by a forensic psychologist. 3. Although the risk assessments are not validated for standalone risk assessment determinations, they are one of the documents the board's hearing officer will review at the risk assessment hearing scheduled for June 13th. 4. The board released the assessments to the parties today. And 5. The parties were directed to maintain the confidentiality of the reports. Additionally, the governor's office also informed me that it had informed the court that although the board's final risk assessment conclusions will not be ready to share until the June 13th hearings, the court could request the governor to ask the board to make the reports available to the court for its review prior to the resentencing hearing. I'm sure it's like, okay, all he needs to do is get a link sent to him and he downloads it just like the DA did. So it's not like it's going to take them that long. They already have it in that format because that's how it got to everybody else. So it's already in like a downloadable format. But but then what the hell is Governor Newsom coming out and saying, these aren't even complete and you're wrong about this and we've only completed one portion and even that's subject to change. So whatever they're talking about in this, it's not accurate because Gavin Newsom has already come out and said he's corrected the record. So, additionally, the governor's office also informed me that it informed the court that the board's final risk assessment conclusions will not be ready to share until the June 13th hearings. The court could request the governor to ask the board to make the reports available. The people believe that it is very important that the court request and obtain a copy of these comprehensive risk assessments prior to holding a resentencing hearing in this case. It is appropriate for the court to review all available information, especially risk assessments, when evaluating whether Erik and Lyle Menendez pose an unreasonable risk of danger. In fact, the court has received and reviewed prior risk assessments for both Erik and Lyle Menendez. Those reports were included with the original resentencing petitions filed by the prior district attorney and cited extensively by the defense in this case. It would be unfair to the parties and the court to rely on outdated risk assessments, while what we have now is not going to be the final version anyway, so what's the point? Without considering the most recent risk assessment. The court should now obtain and review the most recent and updated risk assessments before making any resentencing decision in this case. The people request that the court have a complete up-to-date assessment of the inmates before evaluating the appropriateness of resentencing. The people therefore urge the court to request the recent comprehensive risk assessments for both Erik and Lyle from the office of the governor. To the extent the court is not provided a copy of the risk assessments from the parole board prior to the resentencing hearing scheduled for April 17th, the people request that the court continue this matter until the date after the court is able to obtain copies. I declare under penalty and perjury the laws of the state of California that the foregoing is true and correct. And that is from Habib Balian. And that's just saying that it was mailed, served, declared, the declaration of service. So it was put into docket, or not in the docket, but it was served to all the parties involved. So that is the motion from the DA's office. We're gonna go back to the video now. All right, so we're back to the video. This is Nathan Hochman after he made his argument for this motion and the judge denied it. So the hearings are going to take place. This is amazing, amazing news. They are scheduled for today and tomorrow. They're going to take place, and Nathan Hochman's going to just let out all of his hot air for a few minutes. I have it sped up now to 1.25 because I just don't want to listen to him. He drags on and on. So, but yeah, so I don't know if Aragos comes out again. Well,
good morning, everyone. Today,
doesn't look like it.
we are going to have a resentencing hearing that is not unexpected. As you're well aware, there were two paths to get to this. We're going to have a.
Did you hear that? He said we're going to have a resentencing hearing that's not unexpected.
Well, good morning, everyone. Today, we are going to have a resentencing hearing that is not unexpected.
Meaning he lost. The judge denied his motion.
As you're well aware, there were two paths to get to this resentencing hearing. One was the court's own motion, and at no point did we oppose that motion. In fact, we said we were prepared to go forward with that motion. The second path was the prior district attorney's motion for a resentencing hearing. We sought to withdraw that motion because that motion left out a huge amount of key facts for the court to consider into whether or not the Menendez brothers have been rehabilitated and whether or not they continue to constitute an unreasonable risk of danger to society. Those facts and all facts are not facts that we fear. We want all facts to come out at this hearing, good, bad, or indifferent, facts or facts. The other side chooses to start the factual picture not back in 1989 when these brutal murders occurred, but when they started to serve their prison sentences in 1996. While those facts over the last 30 years are very important, so too are the original facts of the brutal murder and what happened at that time. Because we believe, and the California courts confirm, that in order for someone to be rehabilitated, they need to fully come clean with the entire breadth of their criminal conduct. In this case, the Menendez brothers, for the past 30 years, have not come clean with that information. For instance, they have perpetrated a lie of self-defense. It wasn't their original story. It was actually their fourth story on why they brutally killed their parents. And as we've shown in an 87-page filing with the court, the Menendez brothers concocted this self-defense defense because they had a pre-planned alibi hours before where they were going to supposedly be at Batman the movie when these killings occurred. They bought the shotguns that they ended up using against their parents 2 days before in San Diego using a fake ID and a fake address in order to make sure the shotguns could not be traced back to themselves. When they committed the murders themselves, they staged it to look like a brutal mafia killing, shooting their father through the back of the head, their mother who lied dying and bleeding on the ground. They reloaded the shotgun, put it up to her cheek and pulled the trigger. And then after the parents were dead, they shot them each in the kneecaps in order to stage this as a mafia killing. They then, as you recall, originally said, we didn't do it, that there is someone else who did it. Originally, they said the mafia actually killed their parents. And had they not actually been caught and arrested and had tapes come forward where their confessions were identified, to this very day, I believe, they would have perpetrated that original lie that they weren't involved in the killings at all. But when they got caught, when it was on tape, they had to admit to it. But they didn't just admit to the killings, they then concocted this self-defense defense, that their parents were going to kill them. And when I say parents, I mean both Jose and Kitty Menendez were going to kill them the night of August 20th, 1989, so they had to shoot them first. Of course, that is a lie. And they went beyond that initial lie of self-defense. They perpetrated additional lies where they tried to get one of the brother's girlfriends to say that the father was a violent rapist. She refused to say that. They did try to get another girlfriend to say that the mother had tried to poison the entire family. Lyle Menendez actually wrote a script that came out. And word for word, that is what this additional girlfriend testified in the first trial. But after the script came out, she actually didn't testify in the second trial. Yet each Menendez brothers testified to the same additional lie, that the mother tried to poison them. Now, the reason we focus on what happened back in the 1990s is not because it happened in the 90s, is that because it's happened over the last 30 years. In order to be truly rehabilitated, you have to acknowledge the full breadth of your criminal conduct, your cover-up, and your lies. So the Menendez brothers, instead of coming clean over the last 30 years, when they were not just in their 20s, but their 30s, their 40s, and now in their 50s, as recently as an interview they did on TV about a week and a half ago, they have had every opportunity to come clean and say, look, we did it. We lied about why we did it. And here are the lies that we have told, and we want the world to understand that we now understand all the breadth of our criminal conduct and are prepared to be rehabilitated, be resentenced, and returned to society. They have not done that. And when people say, does the prosecution oppose resentencing, the answer is not no. The answer is not yet. And the reason I say not yet is that we have identified a pathway for the Menendez brothers to come forward, acknowledge all the lies they have told for the past 30 years, and then at that point, if they do it unequivocally and sincerely, and they convince the court, because ultimately the court has to make the decision here, then they can then say to the court, we have come clean, we have been rehabilitated, we no longer constitute a risk of danger to society. But until that happens, the answer is not yet for resentencing. Now, we have actually filed, one of the issues that has come up recently is that we filed a motion dealing with a report that we received from the parole board 2 days ago on April 15th. We have not worked, the district attorney's office has not worked with the parole board, we have not been in contact with the parole board, yet we received a comprehensive risk assessment from the parole board in connection with the parole board's activities for the June 13th hearing they're going to have. When we received that risk assessment, we believed it constituted additional facts that the court should consider in deciding whether or not the Menendez brothers do pose a risk of danger to society. These additional facts are based on a review that the parole board does that is comprehensive. They look at all the records, the prison records, the interview records, the reports in the prison. They talk to various people throughout the prison system about the Menendez brothers, and then they prepared a report.
Is it just me, or does he just love to hear himself talk? He just goes on and on and on.
That analyzes their view of the comprehensive risk that the Menendez pose of potentially being a danger to society. So we wanted to make sure that the judge got a copy of that report and considered it in connection with this sentencing. And by the way, that report, as it pertains to the parole situation, is just one piece of the information that the parole board will consider on June 13th when it conducts its own hearing. But again, it represents additional facts. And the prosecution doesn't fear facts. We want every single fact, good, bad, or otherwise, to be before this resentencing judge so that he makes the right decision.
Yeah, right.
So we basically said, the judge, if you want additional time in order to get this report and to consider it, we, the prosecution, are willing to agree to any additional time you want. And by the way, if you don't need any additional time, and you can get this report through a request to the governor's office, and you can consider it in connection with the resentencing hearing, we are ready to proceed. So what you will see today is we are proceeding on this resentencing hearing. We believe that the defense will call a number of witnesses as part of the proceeding. We will then at some point have argument. We hope that the court will then get this comprehensive risk assessment point at some point. And then we don't know what the court's ultimately going to do. Will the court rule from the bench at the conclusion of the hearings, probably tomorrow? The court could do that. Could the court take it under submission and decide it wants to provide its thoughts and its opinion in written form and issue an opinion? That too is an option. Could the court have an additional hearing at some point where the court wants to hear additional argument on the various factors and either rule from the bench or rule in writing? That too is an option. So I don't know exactly how the court would like to proceed, but the prosecution is ready to proceed today. We've always been believing that this resentencing hearing would occur. It is going to occur. And again,
Then why'd you try to stop it so many times?
we don't oppose. Our answer to resentencing is not no, it's not yet. I'm open for questions.
The brother's attorney has described you as a 90s Neanderthal and how you view this case. What's your response to that?
Again, with respect to defense attorneys, there's an old adage. If you don't have the facts, pound the law. And if you don't have the law, pound the facts. And if you don't have the law or the facts, pound the prosecutor. And that's exactly what the defense strategy has been. Because we don't fear the facts, all the facts that are favorable to a Menendez resentencing, the facts that are not favorable to a Menendez resentencing. Bring on the facts. We do not in any way view the facts in a myopic way, focus just on the 90s facts, because again, the 90s facts are the ones that we're pointing out have continued all the way to this present day, where the Menendez brothers have chosen not to come fully clean with the full breadth of their criminal conduct. They could have done it yesterday. They could have done it a week ago. They could have done it during their prison interviews. They could do it interviews with any of you folks. They chosen not to. It's that choice.
Because you're asking them to lie, you frickin' idiot. You're asking them to lie about their truth, lie about their upbringing and what went on in that home. You're asking them to deny the abuse that went on in that house, which is insanely ridiculous and rude and just completely unself-aware. An abuse victim, to deny them the fact that it happened is like one of the worst things you can do. And that's what he's trying to do, is to like take that power away from them.
That shows that they are not ripe for resentencing today.
Do you expect to hear from them during this hearing?
I'm sorry,
Do you expect to hear from the brothers and perhaps what you're listening for during this resentencing hearing?
again, that is a choice of the Menendez brothers and their counsel. So I don't want to determine for them or even give expectations. We've laid out a pathway that we believe the Menendez brothers can finally come clean. They can choose to go down that pathway or not. The judge is not.
She asked something. It's very hard to hear the questions. It's hard to hear all of it, but she asked something along the lines of, something the defense tried to get the judge to admonish your office because of showing the crime scene photos from last week. So here's his response.
Not any words for me, but let me address what happened. The Menendez brothers, as you're well aware, for 18 years, between 2005 and 2023, had this case lie dormant. And then in 2023, they filed a habeas motion. And then in 2024, there were Netflix specials and documentaries that came out that showed those brutal crime scene photos to millions and millions and millions of people to this very day. We have described, because we believe that the starting point in any rehabilitation starts with the brutal murder. And we have described in words repeatedly in all our submissions the brutality of this murder. 13 shotgun blasts, again, one through the back of the father's head, one to the mother at point-blank range as she lay dying on the ground, and then through the kneecaps after each one was dead in order to stage it as a mafia killing. We have described that repeatedly in words, and there's never been an objection to that. There was never an objection to the fact that these crime scene photos were viewed very publicly and put out publicly for millions of people to see. Now, at the hearing that we had the other day, we described again in words the brutality of the killing, not to do it gratuitously, but because we believe that the rehabilitation, that the coming clean with all the lies starts with the murder itself, the brutality of it, the fact that the Menendez said that they had nothing to do with the murder for 6 months, the fact that the Menendez brothers staged it as a mafia killing, and you have to describe exactly how it was staged as a mafia killing in order to make the point. Now, what we did at that...
All of these facts have already been litigated twice. Now the third time. They had 2 trials. So all the things that he brings up, it's not new. It's all stuff that the jury and, they already came up with. That's not the point. The question is, have they changed? Have they rehabilitated? Are they dangerous to society? And the answer is yes, yes, and no. So they should be free. Their continued imprisonment doesn't serve justice anymore.
At time is we showed a crime scene photo as part of our presentation. What we've apologized for is that we did not alert the defense and the Menendez family that in addition to doing what we had done many, many, many times in public, which is to describe the brutality of these killings in words, that we were also going to show an additional photograph. We've apologized for that. We've made it clear that if we ever were to do it in the future, we would provide advance notice, by the way, not just to the Menendez family, but to anyone in the courtroom who might be seeing this photograph in order to prepare them that if they want to leave at that moment
Well, aren't they just so special because now they're like, "Well, by the way, we'll do it for anybody, not just the family. We'll warn everybody."
in time, they can. We will not be presenting a crime scene photo as part of the next 2 days resentencing hearings, and that's our position on this issue.
Yeah, what about what risk assessments say that you want the judge to see? What's this new information?
I'm not at this point. I'm not going to be commenting on the contents of the comprehensive risk assessment.
Yeah, can you talk about how there's arguments that you conflated resentencing with parole here? Judge Justice ruling last week said that the analysis had nothing new last week, and that the inside standard you keep citing is more relevant to parole than the sentencing. The report you're asking for the continuance around today was also prepared for purposes of parole and sentencing. So can you just explain? Do you disagree with that interpretation?
We do in part, and what we disagree with is that the focus of both parole and the focus of a resentencing hearing is on rehabilitation and the risk of danger to society. Those are the same standards that apply for resentencing as apply to parole. And the California Supreme Court has weighed in, as have other California courts, on what constitutes both rehabilitation and what constitutes a risk of danger to society. One of the factors that they have focused on has to do with insights, exhibiting insights into the full breadth of your conduct. And they have said explicitly that if you have minimized your criminal conduct, which we believe the Menendez brothers have done by perpetrating their self-defense defense, and never acknowledging the lies concerning saying that their mother was going to poison the family and their father was a violent rapist, that when you continue to minimize your criminal conduct, you do not exhibit full insights into it. If you do not exhibit full insights into it, you are not rehabilitated. If you are not rehabilitated, then you continue to constitute a risk of danger to society. So that's how those topics are actually not conflated. They overlap. The same standards that will apply in the parole hearing to rehabilitation and risk of danger to society are the same standards that will be considered in the resentencing hearing.
Are you calling any witnesses of your own today?
I'm sorry?
Are you planning to call any witnesses of your own today? Who are we
I believe today the defense will be calling witnesses, yes.
Who do we expect to hear from?
Received word of the CRA on Tuesday, filed that motion late Wednesday. Why the gap? Why not alert the judge on Tuesday when you first started were able to read what was in it?
So after we received the report,
That was a really good question. He said you received the report on the 15th, and why the delay, why the 2-day gap to, get this filed that you were going to, try to continue. Why the 2-day gap between? It's a really good point because I feel like they did it just to ambush the defense.
we had not asked for that report. The report came to us somewhat unexpectedly. We didn't actually know the parameters around that report and what could be released, what could not be released, whether or not the court had received it or not received it. It took us a little bit of time to actually figure that out over the next day, and at the point we realized that the report could be received by the court if the court requested it of the governor's office, that's when we filed our continuance to alert the court that if the court wanted to do that, we were prepared to allow the court additional time to do it. And by the way, the court's own choosing, if the court either chose not to receive that report or didn't need additional time, we were prepared to go forward with the resentencing hearing.
The judge has received the report.
I do not know one way or the other.
Do you believe the father molested them, though? Do you believe it?
So my personal belief on sexual abuse is not actually relevant for these resentencing hearing. The central defense in the Menendez case was not sexual abuse. The central defense, the perpetrated, concocted defense, was actually self-defense. And that's not Nathan Hochman saying that. That is Erik and Lyle Menendez testifying to it. As we've shown in our papers and in the courtroom proceeding, both Erik and Lyle Menendez, when asked the question, was sexual abuse the reason that you killed your father and your mother, the answer was no. What was the reason you did it? Because we believed our parents were going to kill us that night. Their attorney confirmed that as well. Leslie Abramson has said that sexual abuse does not justify murder. It never did, and it never will. That's a quote from her own attorney. So the focus today, I believe, will be on the self-defense defense as part of the lies that the Menendez brothers continue to tell to this very day.
For what you've seen, there's some conflicting information. So the state has said only one component of that risk assessment has been released and that it's also subject to change. So it's essentially a draft. They said the full version would be released on June 13th. But what I'm hearing from you, if I'm hearing correctly, this is the comprehensive risk assessment. So what exactly is it that you're talking about?
So the document is called a comprehensive risk assessment. It's not called a risk assessment, and then I added the word comprehensive on top of it. It's actually called a comprehensive risk assessment. It has been provided to, at this point, our
Nathan Hochman is such a tool.
I don't know if the court has actually asked for it and received it. And again, the governor has indicated that it is part of the information that the parole board will receive. Again, it is not the final or the only document that the parole board will receive and rule on. It's probably subject to change over the next 60 days or so. There'll be additional information, I am sure, that the Menendez brothers and their counsels will bring to the attention of the parole board to additionally consider. So again, to the extent it has facts, useful facts, one way or the other, that either justify resentencing or don't justify resentencing, the prosecution does not fear those facts. We just want every part of the factual picture to be before the judge when he makes his decision.
From what you've read so far, the judge is not accepting your motion to delay. Resentencing is going forward for today. Did the judge say anything about that risk assessment? Is that going to play any part in the next 2 days?
We'll find out in court today what the judge decides on either asking for the risk assessment or his analysis of the risk assessment. I don't have that information right now.
From what you've read so far,
delay? Has he not ruled on it at all?
I think that he will rule on it momentarily. I would imagine it'll be probably one of the first things he rules on. And again, we made it clear in our own motion that the request we are considering is basically for the judge's benefit, not the prosecution. We're ready to proceed. And if the judge is ready to proceed, we'll start calling witnesses, or the defense will start calling witnesses today. And if the judge then needs some additional time to then review the comprehensive risk assessment or even ask more questions about it, we made it clear that the prosecution is willing to certainly give the judge any additional time he needs.
from what you've seen of the risk assessment so far, does it back up your claims or your arguments and your belief?
I won't be commenting on the contents of the risk assessment at this point.
Can you tell us who you expect to call in this hearing? I know you said you might not present today, but of course.
The defense will be calling witnesses today. We'll make a decision after the defense calls witnesses whether or not we need to call any. All right. Thank you all very much. I appreciate it.
Thank you.
All right. That was Nathan Hochman. I'm going to see if, I don't know if Garagos comes out and does some more announcements or what. 'Cause he said he would come out afterwards, but I don't see him. So the rest is a live stream of them just, waiting outside for any press moments. Yeah, I don't see Garagos coming out. So we will wait until later after the resentencing. So there you have it. Yeah, now we're about caught up. Oh, the live stream has ended. So that's it. No more announcements. We will, I'm sure, get more announcements throughout the day, and I'll do an update sometime later. I think I'm going to skip Friday's Jamie Pisarcik's testimony because we've got all this other stuff going on. So if you haven't already, just so you know, I have read through the 88-page document from Nathan Hochman's team, basically saying all the lies that they like to spew about the Menendez brothers case and why the brothers shouldn't be resentenced. So I went through that document, and then today I have premiering on my channel is the defense's response to that. It was a 31-page document with a bunch of exhibits, and we went through that. We also go through one of the exhibits in there, which is very interesting, is the Suran case of Robert F. Kennedy's, the person who assassinated him, and why it's different and extremely different than the Menendez brothers case, and how he originally accepted responsibility, but then said later on that he wasn't responsible and he didn't do it. So there's a huge, huge difference, and we go through that on that channel or on that stream that's currently premiering right now. This I'm just going to do, I'm not going to premiere it, I'm just going to put it up there, and then you guys can watch it at your leisure because it is breaking news. So I want you guys to be able to watch it whenever you need. And upcoming, so tomorrow you will have the defense's response, or I'm sorry, the state's response to the defense's response to the state, if that makes sense. And then we'll have also, I'm going to do the reading of the, is it a lawsuit? I don't know what it is exactly. It's a motion from the family, the Menendez family and Anderson family, trying to get the LADA's office to follow Marcy's law, which protects their rights and to not be, you know, shocked by gruesome crime scene photos of their loved ones in the middle of a hearing. So that's to protect them. we'll go through that as well tomorrow. So that'll be tomorrow, just so you guys know what's going on because I'm doing a lot of like separate Menendez videos this week because of the resentencing hearing. So just to give you guys a heads up, and then next week we'll probably go back to our regular Tuesday, Friday schedule of reading through the 1996 Menendez trial transcript. So thank you guys so much for being here with me. I appreciate you so, so much. Please hit the like button on your way out, and I will see you guys in the next one. Take care. Bye now.